Judgment in the matter having been reserved on the 18th August 2025, it is hereby read. The petitioner is herein seeking to be released on bail following his arrest on 2nd July 2025. He was subsequently charged and remanded in custody on a charge of sedition for contravening Section 76(2)(b) of the Penal Code Act 2010, read together with Section 109 and other additional charges thereunder. Before the Maseru Magistrate Court in criminal trial 615 of 2025 on 4th July 2025. He is currently awaiting trial at the Maseru Central Correctional Facility. He is a member of the Lesotho 11th Parliament and a leader of the Basotho Government Movement, BCM. He is accused of misusing his position to confuse and/or divide the Basotho nation and violate the dignity and reputation of the royal family or His Majesty. He is purportedly reclaiming a territory he refers to as Basotholand and says it has nothing to do with Lesotho. Yet, according to the Crown, he knows that historically the said land was part of Lesotho as it currently stands. He said to claim that he wants Basotholand restored to its owners without being authorized to do so by the government of Lesotho, but through the use of seditious words or acts. The Crown submits that the petitioner's mission is to spread confusion amongst the Basotho nation, thereby threatening to destabilize Lesotho. The petitioner denies that he is involved in any seditious activities, either through words or deeds, and implores this court to release him on bail under the following conditions: that he pays cash deposit in the sum of 5,000 maluti, that he be allowed to continue with his employment as a member of parliament in the Lesotho's current 11th Parliament, that he attends his remands on times that the remanding court may see befitting, and that he reports himself to the police at police headquarters in the Maseru city in the Kingdom of Lesotho on every last Friday of each month. Having read papers filed of record and heard the parties, the court may, in its discretion, grant or refuse the bail petition. In the event of bail being granted, the court generally imposes conditions designed to prevent the accused from absconding, b, committing further offenses, or interfering with witnesses or otherwise obstructing the course of justice. In motivating his application for bail, the petitioner contends that he will cooperate with the police, that he is a Lesotho citizen and a holder of a diplomatic passport, is a married man with minor children and tends orphans in his church, and is an overseer of the Calvary Mission Church situated at Hatetsane and other parts of the country. It is the petitioner's case that he is prepared to stand trial and vindicate himself, and that he would never leave this country and family for anything. This application for bail is opposed by the Crown. The Crown insists that the preferred charges are genuine and are supported by evidence filed in the docket, that he is likely to abscond once released on bail and not stand trial, thereby evading the ends of justice. It is the Crown's case that the petitioner seeks to be released on bail so as to continue committing or furthering the alleged offenses. Further, that he is a flight risk as he spends most of his time shuttling between Lesotho and the Republic of South Africa, and that even on the day of his arrest he was from South Africa. That apart from on the end of his arrest, his passport reflects a lot of movement between Lesotho and South Africa. Annexures LP and DP were annexed. The Crown contends that his assertion that he fears going to South Africa, as he has been moving freely and peacefully between the two countries, even when he was allegedly in hiding. that is likely to interfere with police investigations and Crown witnesses to the prejudice of the administration of justice. Reacting to the latter, counsel for the petitioner argued that the petitioner is not in a position to interfere with witnesses which have not even been identified. Section 991 of the Criminal Procedure and Evidence Act, the CPNE, provides that every person committed for trial or sentence in respect of any offense except sedition, it's emphasized, murder or treason may be admitted to bail in the discretion of the magistrate. It therefore follows that sedition is an offense bailable at the High Court. The power of the High Court to entertain an application for bail is conferred by Section 109 of the Criminal Procedure and Evidence Act, which reads that the High Court may, at any stage of the proceedings taken in any court in respect of an offense, admit the accused to bail. The decision whether or not to grant bail is an exercise of a discretion, which must of course be exercised judicially and not arbitrarily or capriciously. According to David Lidingwana Jonathan versus Director of Public Prosecutions, the court therein, citing with approval the case of S versus Isaac, stated that in exercising the discretion whether or not to grant bail, the guiding principle is to uphold the interest of justice by balancing the reasonable requirements of the state with the requirements of our law as to the liberty of the subject, adding that the court must always bear in mind that presumption of innocence operates in favor of the applicant, even where it is said that there is a strong prima facie case against him. But that if there are indications that the granting of bail will defeat or frustrate the proper administration of justice, then the court will be fully justified in refusing bail to the applicant. The right to personal liberty is entrenched in Section 6.1 of the Constitution of Lesotho, 1993, the CPNE, and the common law. Bail being an integral part of the fundamental right to liberty, a person who is charged with having committed a criminal offense is, if in detention, entitled to be granted bail, subject to conditions that the court may impose to ensure his or her attendance at trial. The right is, however, not absolute and is qualified by the conditions stipulated thereunder, including that a person may be detained or arrested under subsection E upon reasonable suspicion of having committed or being about to commit a criminal offense under the law of Lesotho. Section 12.2a of the Constitution guarantees this right to a fair trial and provides that every person who is charged with a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty. In petitioning for bail, counsel for the petitioner underscored the presumption of innocence, that the petitioner is innocent until proven otherwise. However, the court in S versus Dlamini issued a caveat on the presumption of innocence, that there is widespread misunderstanding regarding the purpose and effect of bail. Manifestly, much must still be done to instill in the community a proper understanding of the presumption of innocence and the qualified right to freedom pending trial. The ugly fact remains, as observed in the above case, that public peace and security are at times endangered by the release of persons charged with offenses regarded as serious. The discretion exercised by the court in the grant of bail is a fine balance between many interests, which include public interest, interest of justice, integrity and reputation of the judiciary, maintenance of the society's trust in the administration of justice, a demonstration of societal accountability in the exercise of judicial discretion, as well as the interest of the petitioner for bail. In order to assist courts in striking this balance in the exercise of the judicial discretion in respect of bails, the following factors have been found helpful by the Namibian court in S versus Atchison, per Mohammed A.J. Evidential burden, incidence of, seriousness of the charge, degree of implication, motive to influence evidence or witness, flight riskiness, stringency of conditions that may safely be imposed by the court, public interest, exceptionality of the circumstances, and societal duty and integrity of the court in criminal justice system. This case has been quoted in a plethora of authorities on the grant of bail in this jurisdiction, including in Bolofo and others versus DPP. The exercise of the judicial discretion will certainly differ from case to case, and the weight of each factor will also vary from one case to another. Applying these principles to the case at hand, the petitioner avers that he is a Lesotho citizen, holds a diplomatic passport, is a married man with minor children and tends orphans in his church, is an overseer of his church, and has fixed assets in Lesotho. The court also notes that public interest, interests of justice, and judicial integrity may outweigh the positive personal circumstances in matters of bail. The court will at this juncture weigh these positive attributes against the principles outlined on the grant of bail. Sedition is defined as conduct or speech inciting people to rebel against the authority of a state or monarch. The crux of the offense is the words of or conduct that is deemed seditious. Counsel for the petitioner argued that sedition is not a serious offense, hence there is no penalty attached to it under Part 10 of the Penal Code. He relied for this assertion on Section 109(3) thereof. This court has a contrary view. As far as it is concerned, sedition is a serious offense. In terms of the said section, if the petitioner is found guilty, the discretion is left to the court. The court confirmed in David Lidingwana that the seriousness of the offense is one of the factors for considerations by the court in a bail application, in as much as the possibility of a severe sentence is in itself a potential inducement to an accused person to flee rather than stand trial. On flight riskiness, counsel for the petitioner argues that the petitioner is not a flight risk. He relied heavily on the case of Lipholo versus the DPP in his submission that the petitioner was granted bail despite having fled for a period of 7 years. Countering this argument, the Crown said the petitioner, Lipholo, was not arrested but voluntarily surrendered himself to the police, unlike the petitioner herein who was arrested. The Crown insisted that the petitioner is a flight risk. The petitioner averred that he possesses 2 passports, the diplomatic as well as the regular passport. The court takes judicial notice of the fact that the 2 passports may be used interchangeably. It is the Crown's case that the petitioner's frequent movement outside this jurisdiction are an indication that if released, he is likely to abscond. Also that he had traveled recently to Botswana on 2nd February 2025, to South Africa on many occasions, and to Ethiopia on 7 April 2025, and to Eswatini on 6 May 2025. The Crown contends that the petitioner uses various ports of entry, including recently Kofontein in Northwest, Tlokong in Botswana, the Botswana Airport, marked SSKA, Maseru Bridge, Van Rens Gate, and Fitzburg Bridge. As the Crown puts it, the petitioner is slippery. The petitioner possesses a multi-entry visa into the United States of America, dating from 17th January 2025 and expiring on 14th January 2030, annexed to the opposing affidavit as DP at page 76 of the record of proceedings, further motivating its point that the petitioner is likely to abscond if released on bail. and defeat the ends of justice. The Crown quoted Article 3.1 of the treaty between the Government of Lesotho and the Republic of South Africa on extradition, entered into on 9th April 2001, which reads, extradition shall be refused in any of the following circumstances: where the offense for which extradition is requested is considered by the requested state to be a political offense or of a political character. Lesotho is a signatory to the SADC Protocol of Mutual Legal Assistance in Criminal Matters. Article 6 thereof provides that assistance may be refused if, in the opinion of the requested state, the request relates to a political offense or an offense of a political character. It is the Crown's case that charges leveled against the petitioner are of a political nature. In the court's view, they are, having perused through the counts. The court wishes to emphasize that although the right to personal liberty, including bail, is guaranteed under Section 6.5 of the Constitution, like other rights, it is not absolute. In conclusion, in its exercise of a discretion to grant or refuse bail, the court acts with impartiality, without bias or prejudice, fear or favor. The attitude of the Office of the DPP in opposing the bail is not conclusive in its decision to grant or refuse bail. It will look at all the surrounding circumstances of the case to determine whether the petitioner will stand trial and not abscond. Remarks of Cotran CJ in R versus Emmanuel Ndoi, it's unreported, that in an application for bail pending trial, it has often been said that the courts must start with the premise that every accused person is presumed innocent until the contrary is proved, and should lean towards the granting of bail rather than refusing it. The rule is, of course, subject to certain qualifications based on the principle that it will not be granted if the interests of justice will be prejudiced. A determination whether or not the petitioner's arrest and remand into custody are constitutional for excessiveness or overbreadth has not yet been determined, and is not an issue for determination by this court in this case. A conspectus of the above considerations leaves the court with no alternative but to refuse bail. In the result, the petition fails and release on bail is refused. Upon the reasonable time within which investigations ought to have been concluded, the petitioner may still approach this court for reconsideration of the question of bail. That is our issue. The court shall adjourn.